Good afternoon, worldwide audience. This is the In My Opinion show with Ron Barry Robinson and friends. Today we will host Supreme Court Justice David Viviano. I apologize for the condition of my voice, but we'll take what God gives us. I hope that you, the worldwide audience, will appreciate the efforts in bringing this show together today under these circumstances. But now, let's get to Justice Viviano. Welcome, Justice David Viviano.
Ron, thank you very much. It sounds like you have a cold. I just got over one myself, so I hope you will be feeling better soon.
Thank you, Judge. This is Henry Hatter, not Ron. Ron is the host.
Oh, I'm sorry. This is Henry's voice.
I recognize your voice, Justice. Thank you.
Henry, well, my well wishes go then to you. I hope you're feeling better soon.
With that coming from the judge at the Supreme Court, I should automatically get feeling greater immediately. But now on for Justice Viviano. Justice Viviano, would you tell us who is David Viviano?
I certainly will, Henry. I have been a justice of the Michigan Supreme Court for almost 20 months now. I grew up in Macomb County as part of a large family. I have 5 sisters and 1 brother. My father is a retired judge now. He was a lawyer, has been a lawyer for over 50 years. He and I actually served on the circuit court bench together for a period of 4 years until he retired. Now my sister Kathy is the presiding family judge in Macomb County, so we have a tradition of public service in our family. As I mentioned, grew up in Macomb County. I then went on to Hillsdale College and the University of Michigan Law School. I then had the privilege of working at 2 different large law firms, and one in Detroit and one in Chicago. Then I started my own firm in Mount Clemens, Michigan. I also served as city attorney in Centerline. After that, I decided to run for the circuit court bench in 2006, and fortunately was elected. And I served there in the civil and criminal division with a very busy docket. Interacted with a lot of folks, a lot of litigants, and a lot of lawyers. I also then was appointed to be the chief judge of Macomb County for about the last year and a half of my time there. I'm a rule of law justice on the Supreme Court. I know we're going to talk more about that, Henry, so I'll let you guide the questioning from there.
Justice, again, I want to thank you for attending the Tuskegee Airmen's event at David Rundle's house on the 27th of August. We enjoyed you, and so did our audience. And that's why
well,
today...
I have to tell you, it was a privilege to be there. It was a thrill for me, and to be there with some of the original members of the squadron was quite a high honor. And so I'm grateful that you invited me, and I was just happy to be able to be in attendance.
I hope that you will attend other functions coming up shortly. I will send you information on that later on.
Sure.
But I got a chance to introduce myself to your dad. And what a great man. I didn't know he was part of the court system, but I really enjoyed him. My daughter, my son, and all of the other people did get a chance to meet this distinguished lawyer court family.
Well, he's been quite a role model for me, and a great dad, obviously. He just turned 79 years old this past week, and one of the things we did on my campaign's Facebook page, I did a little tribute to my dad and talked about what he means to me and what he's meant to our community. But one of the really neat things about that was almost 80 different people commented on the Facebook page, family members and friends, and really people in the community, including people who he's interacted with in the court system. Some young people that were, for example, in the juvenile home when he was the juvenile court judge, posted on the website to tell us all really how much his interaction and his efforts have meant to them in their life and their development.
Well, send our best to your dad and happy birthday to him. And now what I'd like to get into some of the philosophical aspects of being a justice, a judge, even a judge. Is justice a universal principle or truth? Can folks who live in this community get the same kind of justice anywhere in the world? Or is justice depends on where you are, who you are, and the circumstances of the times and events that you live under?
Well, that's really a multi-dimensional and philosophical question, and I would say that justice is a universal truth in the sense that it's something that we all aspire to. And by the way, not just those of us who are judges or who wear the robe. I think that all of us in this world who aspire to achieve justice. Having said that, I think there's no question that some countries are better equipped and better structured to allow their citizens the opportunity to achieve justice and to achieve success and happiness in their life. And so I don't think the concept is the same or equally attainable all over the world. In fact, I'm quite certain that it's not. But I do know that it's a central principle, a founding principle of our country, and the reason that our founders designed a system of government to protect individual liberty. They divided the powers of government in order to limit them, to limit the growth and power of the central government. And they did that by dividing that power into three separate branches: the executive branch, who executes the law; the legislative branch, where policy is made; and the judicial branch, where our job is limited to interpreting and applying the law fairly to the cases that come before our court. So I do think, even within our country, I mean, I don't know if your question is getting at this, but based on people's circumstances, are they able to achieve justice? I do think we have, even in our great system, some problems where perhaps folks with different levels of resources aren't able to afford an attorney, for example. And so we are, I know, working in Michigan to improve our system for representation of folks who are indigent, particularly in criminal cases, and I think that's extremely important. We all need to be concerned about access to our courts and access to quality legal representation.
Well, thank you for that response, Justice. As a matter of fact, this show goes all over the world, and there will be people from maybe China, Germany, in the upper Middle East that might send in responses to the show when you're talking about universal issues like this. So we'll keep you apprised of that as well. Can you hear me?
Yeah, very,
okay?
very interesting. Just as a side note, in Macomb County, we've been receiving for the last few years visitors from China who are interested in the study of law and public policy. And it's been very interesting for us to give them some exposure to our legal system, the American legal system, but also for all of us here to learn more about the Chinese legal system.
Yes, you will be getting some blogs back in, I'm sure, and the folks here at the studio will pass that on to us, and we'll pass them on to you.
Okay, terrific.
You may not like all of them, Justice, but we hope you do.
Well, that's part of what it means to run for office and to try to make a difference in an open society like ours, is that folks are certainly entitled to their viewpoint. And I don't expect everyone to agree, and frankly, life wouldn't be as interesting, Henry, as you know, if everyone agreed all the time.
I do. And now, Justice, I'm going to get to one of those philosophical principles again. Now, when a conservative justice proclaims that he or she is a rule of law justice, then what does that mean? And why should we care about that?
Well, first of all, as I already mentioned, I'm proud to proclaim that for myself, that I'm a rule of law judge, and that means that I understand that a judge's role is limited. It's not my job to decide what my preferred outcome is in a given case, or whether I think that the policy of the legislature is a good policy or a bad one, or whether I should replace it with my own. My job is to work within the system that our founders put in place, the constitutional structure that we have, and to apply the law, take the law from the legislature, interpret it fairly according to its plain meaning, the meaning that the folks who would have understood at the time, for example, that the Constitution was ratified, the language of those constitutional provisions, or the language of statutes at the time they were enacted by the legislature. The reason folks should care about that is because if we want to remain free as a people and have a representative democracy, and have legislators who are able to, to respect the will of the people, to change the policy direction of our state and our nation by electing new legislators. That's how our system functions. That's how we remain free as a people. And otherwise, we end up with judges who are not elected as policymakers, but who act because they think perhaps that they're wiser, for example, than the legislature or the people who elected them, and who are making decisions that are not legitimate without legal authority. So I think folks who, in this country, we're fortunate to have a pretty good understanding, I think, people at a gut level of how our system works, and that we want judges who are umpires, who are calling balls and strikes, and who aren't changing the rules of the game as we go.
Justice, can you cite at least one example, because I'm fuzzy about this right now, where just the opposite has happened in our legal system, where there were instances where judges were making law instead of judging it?
Well, the concept, the alternative concept, is known as judicial activism, and there's been a debate in this country for some time in the law schools and in the court system between rule of law or textualist judges and judges who take a more activist bent. And I can tell you that there's a lot of folks out there who think that cases, if you lose your issue before the legislature, then you just bring a case in court so you can litigate the same policy issues in a different forum. In terms of, I'm trying to think about an individual case that I would bring up. I'm a little reticent to talk about specific cases, but certainly our courts over the years.
Please do not talk about anything that might violate the protocol. I don't intend for you to do that.
Right. No, and I appreciate that. And we'll talk about you. I know you have some other issues you want to bring up, and we'll talk about these things a little bit where I can. But certainly we've had courts who have decided, here in Michigan, the Supreme Court for a period of time, that they didn't like some of the policy measures the legislature passed, and so they are more open to declaring them unconstitutional or coming up with different glosses, putting glosses on the statutory language that have moved us farther away from the plain language and intent of the legislature. And really the job of the courts, and I'm proud to say that I serve on a court that understands that it's our job, is to get us back to the plain language of the law. And another reason why that's important, Henry, I intended to mention this earlier, is that one of the most important things about the law is that it's clear, and that it's stable, and that it's predictable. And it's not just something that's in the possession of lawyers or judges. In other words, the law is there for all of our citizens, and they shouldn't have to go to lawyers to understand what the law means and what their legal obligations are. And so we, as judges, have a duty to interpret the law fairly and according to its plain meaning, because that's how all of our citizens can understand the law and can understand what their legal obligations are.
I hope I'm not boring you with this, but I'm going to go back to the first justice who sat on the Supreme Court of the United States, John Jay, who served for about 35 years on the court, I believe. And of course, in those days, they were developing a format, an outline, an arrangement of how this court system, along with the judicial and the legislative bodies, worked. Would there might have been a chance where John Jay might have practiced a little bit of that?
And practice as a lawyer?
Yes, as a court, even as a court official. Because these arguments did not come about until the evolution of the court system and how American government worked over time.
Yeah, I'm not sure that I understand your question fully, but I would say this. It's really interesting when you study the early court system in the United States, and at the Supreme Court level, not much emphasis was given to the Supreme Court. In fact, when the Chief Justice John Marshall was appointed to be the Chief Justice by John Adams, President Adams had a difficult time finding someone to fill that role, and I think he went to 2 or 3 individuals who turned him down before he ended up with John Marshall. And the Chief Justice Marshall, one of the things that he was able to do was build the court into an institution by working with the justices to arrive at a consensus, at unanimous opinions, and answering the most important questions of the day. And it really added prestige to the court as an institution, and also allowed it to settle some very big, important questions. Marbury versus Madison deciding or establishing the court's power of judicial review, for example, and saying in quite clear language that it's the job of courts and judges to say emphatically what the law is, not what the law ought to be. These are very important, obviously, periods of time when the Supreme Court could have gone in a different direction and been a much less influential body and not fulfilled its constitutional role. Jay was, of course, the first Chief Justice, and I think he only served in that capacity. I have to confess, I'm looking it up on the internet, for about 6 years, which makes sense because it was only a couple years after that John Marshall was appointed by John Adams.
Thank you, Justice, for correcting me here. I had John Jay serving for a lot longer, but it was John Marshall who served this great length of time and who established court protocol, like Washington established the protocol for the White House and so on and so forth. It's interesting that you would add a comment on that, because those are comments that people want to know, the little nuances that justices today, as they look back over history and look at how things evolved and developed. But now I want to get on to another question.
Henry, if you'll indulge me for one more historical observation, because I do love history, and in particular American history, and I want to give one more plug to President Adams, because I don't think he gets the recognition he deserves in our history. He was really a brilliant lawyer and a brilliant constitutional scholar, and helped to design the Massachusetts Constitution, which then became a model for the federal Constitution. But he was also a person in history who is maybe not always known as much for what he did, but as for his ability to pick the right people and put them in the right places to be effective. And so he was instrumental, for example, in having George Washington appointed to be the general of the Continental Army and to run the Continental Army. And he was instrumental in having Jefferson appointed on the committee to draft, along with himself, the Declaration of Independence. And of course, he's the one who picks John Marshall to lead the Supreme Court and build it into an important institution. So it is really interesting when you study the impact that these folks had, and that all of us can have, I think, by working hard and believing in public service and applying ourselves and appreciating the reasons, the things that make this country so great.
Well, thank you, and I think that students around the country who listen to this show will appreciate that, particular people who are studying political science and professors and stuff who may have forgotten or never was exposed to that information. So that helps to broaden their horizon of the American court system and its government system. But I'm going to move quickly to another question here that you might want to comment on, but certainly if this is beyond the scope where protocol prohibits it, then we should rethink this. Is the Michigan Supreme Court likely to undertake the death penalty in light of the fact that what appears to be increases in violent crimes, since everybody can carry a gun? So you got the police, that appears that the role of the police is truncated by the fact that everybody can carry their own defense systems. Would you like to comment on whether the Supreme Court will undertake consideration for the death penalty in Michigan? Sure.
What I would say is that the death penalty as a punishment for serious crimes is an issue that the legislature must determine. The legislature has the sole power to determine punishment for all different types of crimes. under Michigan law. And so at this point, we don't have a death penalty. The highest penalty under Michigan law for first-degree murder, felony murder, or felony murder is life without the possibility of parole. And so under the current system, the issue of the death penalty will not come to the Michigan Supreme Court because it doesn't exist as a penalty in Michigan. It does exist in other states, and it does exist under the federal system. So the only way that someone could be charged with a crime where they would face the death penalty under, or I should say in Michigan, is if the charge, then the crime is prosecuted under federal law. For example, if a federal agent is killed, or if a crime occurs on federal property, then someone might be subject to the death penalty. So that issue is not one that's likely to come before our court until or unless the legislature takes some action on it.
And Justice, that dovetails really clearly in face of the question about the rule of law. Because if you undertook it and it's not a law yet, you would be practicing contrary to rule of law. Is that a correct statement?
Well, sort of. I mean, even the courts and judges really are not in a position under any. I don't think there's any difference of opinion or disagreement on this. Even a judicial activist, I don't think, would try to come up with their own penalty. That's really contrary to the American system of justice. So what happens if you flip it around, for example, is where an activist judge in a place where there is a death penalty, or if you want to look at more at issues that are in Michigan, when we look at the punishments that are out there by the legislature, our job is to, as long as those punishments are appropriate under the Michigan and the federal Constitution, then we should enforce those punishments. That's what a rule of law judge would say. An activist judge might say, I don't agree with those punishments. I think they're too severe. And so I'm more likely to find ways to avoid imposing those punishments, even though it's you can't do it under a strict interpretation of the law. So I don't know if that's helpful.
Yes. Now, let me ask you a follow-up question then, Justice. Has the rave over guns, possession of guns, created circumstances that challenge the court system? Are there more incidents that come to the court and charges against law enforcement or against individuals because they act out in certain ways that where people are killed, and that creates an incident for the public domain? For the legal domain system.
Well, I think,
engaged.
First of all, the U.S. Supreme Court has made it very clear that all of our citizens have the right to bear arms and to possess a firearm for self-protection. And and I think our country that's long been part of our tradition in this country. When it comes to the court system and dealing with assaultive crimes, whether they be crimes with weapons like guns or knives or otherwise, or other types of assaultive crimes, we have, of course, this is what we deal with in the court system, and we, through the jury system, try to determine what happened, what the facts of each individual case are, what a criminal defendant's intent was when certain actions were taken, so that we can determine, so the system can determine whether someone's guilty of a crime or not.
Justice, I got to move on. Thank you, Justice. Hang on, Justice. I got to move on. I got limited time. But I'd like to ask you a quick question. Will the concept of justice change, do you think, when there's a paradigm shift in this country, when it truly becomes a pluralistic majority?
I don't think the concept of justice changes. I think the composition of the country will continue to change, and that will be reflected, I think, in the composition of the folks who serve in the justice system. It'll be reflected in the composition of folks who serve on
Thank you,
juries.
Justice. I got to cut you off, Justice. Thank you very much. You've been a great conversationalist. I'm sure that people learned a lot from you. We appreciate the conversation that we've had with you, and I hope that we can get you back on the show at a later date.
I'd
Thank
love
you
to do
very
it,
much.
Henry. It's great to talk with you, and I hope you feel better.
Thank you, and I hope to see you soon. Goodbye.
All right, take care.